The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials. But on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach. And I really appreciate that. And they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
The following is based on a true feeling.
So, what are we thinking? Is this the one?
You're really good at this.
And that's what it feels like when there's a Century 21 agent in the house. Smarter, bolder, faster.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if you only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers? What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights. What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the legal hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive. And we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Good morning, I'm Julie Woodfin, Professional Development Coordinator, and I wanted to thank you for joining us today. We are privileged to have with us Marcia Waters, Director for the Colorado Division of Real Estate. But first, I wanted to pass along a quick thank you to First American Title for presenting our webcast program, which of course, as you know, is a part of our professional development initiative here at CAR. A representative from First American is with us today to tell us about some of the services they offer.
Thank you so much. It's a real pleasure to be here today. What I wanted to mention to you all is an idea that you've all heard of, but I've seen very few brokers that have actually implemented this idea in their business. And that idea is using video email to stay in touch with your clients. So an interesting fact is that traditional drip emails have about a 20% open rate, whereas video emails have about an 80% open rate. So that can be a very powerful and effective way to stay in touch with your past clients and your sphere of influence. I think what's really powerful about the video is that they actually see your face and hear your voice. It just feels a lot more personal than just reading text in a regular email. So there's a really great program out there that I just started using in my business called BombBomb. They offer a 2-week free trial, so if you're curious to give video email a try, this is a free way to do it. But I really want to encourage all my real estate brokers out there to give this a shot because I think it'll really have a tremendous impact on your business. So thank you so much again and enjoy the webcast.
Thank you again to First American for their ongoing support. Now before we get started with the program, I have just a few housekeeping items. We've allocated an hour and a half for today's presentation, and we'll take a 10-minute break following Director Waters' initial update. If you have any questions along the way, feel free to type those in according to the instructions there on your screen. Depending on the number of questions we receive this morning, there is a possibility that we will conclude early. At this time, I am happy to introduce you to Director Waters. As the Chief Regulator to the industry, she manages the division's $5.9 million budget, oversees a staff of approximately 51 full-time employees, and establishes the direction and division programs based on market and industry trends. In addition to ensuring the licensure and compliance of real estate professionals, she also serves as the administrator for the Real Estate Commission, the Board of Real Estate Appraisers, the Board of Mortgage Loan Originators, the Conservation Easement Oversight Commission, and the HOA Information and Resource Center. So without further delay, I'll hand the program over to her.
Well, good morning. I'm Marcia Waters, and I'm here to give you a division update, primarily focusing on commission projects. We do have quite a few projects going on currently. As of last Friday, you should have all received an email blast letting you know that the commission has adopted a new position statement at CP 44, and it covers coming soon signs. We've gotten a lot of industry inquiries about coming soon signs and the appropriate use of them, and the commission really felt that it was important to address this issue formally through a position statement. The position statement itself basically asks the broker to consider what's the motivation behind marketing a property as coming soon. Is it to allow the seller time to prep the property for sale, or is the broker actually hoping to double end the deal by bringing in a buyer? If it's the latter reason, bringing in to double end the deal, chances are it's going to be in violation of the Brokerage Relationship Acts. What we would also ask is that when you're discussing marketing a property as coming soon, that you have a discussion with the sellers so that they're aware that they may get limited market exposure and they may not get the highest and best offer And that just helps them make the decision on whether they want to market the property in that way or not. We are currently working on revising the advertising rule, specifically E8 and C19. C19 basically deals with the use of broker names, while E8 specifies the regulations behind advertising. I can tell you from the enforcement standpoint, we see a lot of issues with how brokers advertise their names. And so we're looking at merging those two rules together along with kind of bringing it up to current times. I think E8 was written in a time where print advertising was the typical media used, whereas now we need to deal with internet and social media. We presented a very rough draft to the Commission at their June 3rd meeting last week. And basically what we are proposing to do is have a section of the rule that lays out definitions, because a lot of the rules kind of confuse the term of broker and brokerage. So you'll see a definition section. We'll also be addressing the use of trade names. Currently, the regulation only allows you to use one trade name at a time. We would still continue to only allow the use of one trade name. However, we're looking at allowing the brokers to use multiple trademarks. I know that there's one prominent brokerage out there that is currently using different trademarks, and as long as the consumer can figure out who the brokerage is, we are fine with that. So the rule proposes to allow that as well. We're looking at addressing team names formally instead of just in a position statement or in a newsletter article. So it would lay out in the rule that team names cannot incorporate the use of the term realty, real estate, realtors, company, or etc. It can't look like it's a separate brokerage from the one that is actually employing the broker. And then we're going into internet usage. And predominantly what we're looking at is that we want to hold the brokers accountable for making sure that you're managing expired listings or when listings need to be taken off of the websites. So if it's a broker-maintained website, what we're proposing is that within 3 days or so of the listing either being expired or withdrawn, that you make the appropriate changes to the website so that it's not continued to be marketed. If it's a third-party managed website, we're looking at requiring that the brokers submit something in writing to the third party that is managing the website to let them know that they need to take the information down. The other issue that we're looking at dealing with is banner advertisements in social media. If there isn't appropriate space for you to make the disclosure that's required in the license law, which is basically that you're employed by such and such brokerage, what we would do is require that it be one click away. So if you click on the banner, it will take you to a website that complies with the advertising requirement as far as the brokerage, the employing brokerage is concerned. Additionally, if you're communicating with somebody back and forth that knows you're a broker and that you work for ABC Realty, we're looking at basically you're not having to disclose every time you communicate with them in an electronic format. You don't have to put down your brokerage so much. One of the new things that this rule would do is address the use of designations. So if I'm out there advertising that I'm an ABR, I need to be able to present proof to either the commission or the consumer that I am in fact an accredited buyer's representative. We see a lot of time people are advertising that they're realtors or some other designation, and they need to make sure that they are actually have the membership, along with if they're advertising that they were a recipient of an award, they need to be able to provide verification to prove the validity of such claims. So that's the advertising rule. I anticipate that we'll have kind of a more formal version for the commission in August, and we're also going to vet it to the industry because we want to make sure that any regulations that we're contemplating are not a disjunct from industry practices. One of the biggest issues that we're dealing with currently, and we have been dealing with for some time now, are forms. A year ago, the Commission approved a 2-year moratorium on any forms changes for the Commission-approved contracts. I will say that at every Commission meeting, we are seeing disciplinary cases that have some significant forms issue. And to give you an idea of what those are, we see brokers being creative and drafting their own legal documents, which you don't get to do under the license law. You have to be an attorney to do that, and you'd have to be licensed in Colorado. We're seeing failure to use the commission-approved forms when it's appropriate for the transaction. We're seeing brokers insert personal provisions or exculpatory language that benefit the broker into the contract to buy and sell when they're not a principal to the transaction. And as an example, it would be totally inappropriate for me as a broker to insert into a contract to buy and sell that my client's sale is predicated on me getting a certain percentage of a commission. That's not appropriate at all. Some of the other issues that we're seeing is we'll see a form that is not a commission-approved form, and frankly, the quality of it would not leave us to believe that it's an attorney-drafted form. So when we ask the broker where the form came from, they tell us that it was an attorney-drafted contract. We then inquire what attorney drafted it, and the broker is at a loss to tell us. We're inclined to think that the broker either drafted the contract, or they may be borrowing language from another attorney. And we do hear concerns about plagiarizing attorney-drafted forms and using them as their own. We also see brokers that just pull random forms off the internet. There was one form earlier this year that I was made or brought to my attention, and it was a talking points for seller financing. With the changes that have occurred at the federal and state levels, real estate brokers really cannot provide the services that they previously did to sellers who wanted to do a seller finance transaction. If you are offering to negotiate the terms of a mortgage loan, or you're negotiating the terms of a mortgage loan, or you're taking an application for a residential mortgage loan, that all requires a mortgage loan originator license at the state level. There are federal regulations that are in place as well. It's very convoluted and confusing. So if your approach to do a seller finance transaction, you need to refer them as far as if they want you to help with the negotiations of the terms or even with the paperwork, you need to refer them to a licensed Colorado attorney or a mortgage loan originator. And I will tell you that a lot of the loan originators that we talk to are not inclined to even want to go down the road of doing a seller finance transaction. So just be aware of that. Chances are they're going to need to hire an attorney to help out with that. But there was a form that was introduced to the industry, and this was not a commission-approved form, that would have really set up both the brokers and the sellers to be subject to some significant civil penalties, and the brokers were looking at potentially being found in violation of the Mortgage Loan Originator Practice Act, which typically translates to a cease and desist order, a $1,000 fine if it's just a one-time occurrence, but it can escalate to an injunction and some other unpleasant fines. So just be aware of that. Because of the issues that we're seeing with the forms, we have been working on revising the F rules just to make it clear what the Commission's position is. And the Commission's position is that you've got to use a Commission-approved contract when it's appropriate to the transaction. It's been that way ever since I've been with the division, which has been almost 9 years now. What we are looking at, even further clarifying, is that some of those forms need to be specific to the transaction. We're trying to do a balancing act between when a form needs to be specific to the transaction, and if there's not a commission-approved form, obviously drafted by an attorney, versus those transactions where there isn't a commission-approved form, it's drafted by an attorney, but it's used by a broker over and over and over again. So like an addendum, or we might see a lease that would fall into that criteria as well. I will tell you, currently what we're contemplating doing with the F7 rule is clarifying that you've got to use the commission-approved forms when it's appropriate to the transaction or a circumstance that would make the form relevant. But we're also looking at adding the language, the exception to the required use of a commission-approved form is a broker's use of an attorney-drafted listing contract in lieu of a commission-approved listing contract. But in that case, the attorney would have to be the broker's attorney. It can't be some random attorney that doesn't have a client relationship with the broker. And it goes on to include that if a broker uses a listing contract that was drafted by the broker's attorney, the broker is responsible for ensuring that all mandatory disclosures are contained within the listing contract. So your exclusion to having to use a commission-approved form currently and going forward would be the listing contracts. However, you need to use an attorney-drafted one drafted by your attorney. And then we're looking at further clarifying in F7 that when there isn't a commission-approved form that has been promulgated, a broker may complete a form drafted by the broker's attorney that is specific to the transaction and appropriate under the circumstance. However, a broker using a form drafted by the broker's attorney must ensure that the broker understands the form and the form is used and or completed appropriately. That's another issue that we see a lot of the times, is that brokers will buy kind of a suite of forms, and then we see issues because they're not using the forms appropriately. So we want to make sure that you're using them competently, that you know what you're doing, but we are going to have to parse out when you've got to use a form specific to a transaction versus when you can kind of use a template form that has been drafted by the broker's attorney. So as a result of some of the changes that we're looking at doing, one of the directives from the Real Estate Commission last week is that they want to actually define what a standard form is so that there aren't any ambiguities under the Brokerage Relationship Act. 1261-803-4 says that brokers can complete standard forms, including those promulgated by the Real Estate Commission. It's within the Commission's jurisdiction to define what a standard form is, so we're going to be working on that, and that's when you'll start to see us delineating when you use a specific to the transaction form versus a template form if there's not a commission-approved form that works for the transaction that you're dealing with. One of the other F-rule changes that we're looking at doing is F2. And I will tell you that F2B currently says that you can't put any exculpatory language in the contract to buy and sell if you're not a principal. One of the things that we've seen arise kind of out of the changing market is a change in business practices, particularly when you're dealing with a flat fee broker versus a traditional percentage split broker. So if I'm bringing in a buyer to a flat fee listing, I'm going to have a conversation with my buyer about, listen, we negotiated X percentage of a commission for me. That's not going to come to fruition under a flat fee broker. You're going to be responsible for making up the difference. The buyer at that point may want to negotiate with the seller that the seller pay the outstanding balance that I would be owed for my commission. Currently, F2 doesn't really accommodate that scenario, and when it's a point of negotiation between buyer and seller, you're not really putting something exculpatory into the contract. So we need to make kind of an exception to the existing rule for that. We're suggesting that the Commission change the rule to indicate that a broker may, at the direction of a principal party, include language regarding payment of the broker's or the brokerage's commission if this is a term of negotiation between the principal parties of the contract to buy and sell. That would help accommodate kind of the disjunct that is occurring with business practices currently. We're also looking at changing F3, which is the rule on addenda. It's really to coincide the language in F3 with F7 about you can use addenda as long as they're drafted by your attorney. And if there isn't a commission-approved form available that meets the needs already. So we're really not looking at changing any of the industry practices about eliminating your use of using addenda. We just want to kind of refine and make sure that those addenda are drafted by your attorney. You understand them. I know from the Commission's perspective, when they said that they wanted to define what a standard form is, they also want to have some education components with that. And a lot of that will speak to the supervision requirements for employing brokers. They want to make sure that it's included in the policy manual about when you use an attorney-drafted form, along with ensuring that the employing broker is going over those forms with the broker associates so that they are understanding them. Additionally, one of the things that they are contemplating having put in the rule is that there be a requirement that annually the employing broker and the attorney, or whoever the employing broker wants to delegate this duty down to, that somebody at the brokerage is annually reviewing those attorney-drafted forms with their attorney to see if they're still timely and if there's any revisions that need to be made. So that's what we're looking at as far as forms are concerned. I will tell you that at least monthly I get emails that scare me to death because it's like, how do I manipulate the contract to buy and sell to help somebody out who wants to assign their lease purchase option? And that's when I have to tell them, no, you need to contact an attorney. There's no way you can manipulate this form to do that. So that is just kind of further bolstering the Commission's need to actually have to kind of refine the F rules. One of the other things that we're working on doing is at the December retreat, the Commission decided that they wanted to do a position statement that addresses commercial property management. Last year they adopted CP27, or revisions to CP27 back in August. And we did that based on the continued issues that we see both on the enforcement side and also our auditing side. We don't see so many commercial property management complaints, but they did want to release a position statement just to make it clear what the expectations were for commercial property managers. Originally, they had requested that we just kind of expand on CP27, and in hindsight, I think adding it to CP27 is just going to further kind of confuse the issue for the residential property managers. So I anticipate that what we'll do is a separate position statement that's specific to commercial property management. I am in the process of putting together a working group of commercial brokers to assist with that. If you're interested in participating and you have commercial experience, please send me an email. My email address is marcia.waters@state.co.us. And to spell it out, it's marcia.waters@state.co.us. And just put in the subject line CP on commercial property management. That way I know that you're interested in participating in that. But that's kind of one of the goals, is to get at least a draft done this year. And I'm kind of burning daylight since I've got 6 months left, and I get to deal with forms issues as well. So I'm trying to get that up and running as quickly as possible. One of the other issues that was brought up at the December retreat was short-term rental agreements. We've had the position that if it's less than 30 days, you don't have to have a broker's license. However, if you do have a broker's license and you're engaged in short-term rental agreements, the Brokerage Practice Act basically pulls you into the Commission's jurisdiction. And I will say that we see quite a few trust account issues with short-term rental agreements and licensed brokers. One of the concerns that the Commission brought up is they had been hearing a lot of complaints from consumers about kind of bait and switch practices primarily occurring in the resort areas. For example, we've got somebody who's coming from New Jersey and they want to stay for a week in Vail. They send a $5,000 or $10,000 deposit thinking that they're getting a very nice Vail condo. They arrive in Colorado to find out that they've got pretty much a broom closet and their deposit is gone. And unfortunately, the person that is doing the rental is not licensed. So one of the things that the Commission wants to contemplate is withdrawing the position statement that basically says that less than 30 days doesn't require the license. We are going to have the Attorney General's office really kind of look at this issue to see if the Commission has the jurisdiction to be able to assert the authority to say that if you're going to do short-term rentals, you have to be a licensed real estate broker. That's one aspect of it. We've also reached out to the Hotel and Lodging Association because this is really going to affect what they do as well. So we'll be working with them to get their feedback so that the Commission can make really an educated decision, hopefully within the next couple meetings, either in August or October, about what direction they want to proceed. One of the rules that you'll see coming up, in addition to the advertising rule and the F rules, that we're looking at revising is the E&O rule. It was brought to our attention that one of the E&O carriers, and it's not the state, the one that the state has a contract with, but one of the E&O carriers was allowing brokers to exhaust pretty much their claim limits on legal defense. So once it was exhausted on legal defense, if there was any sort of judgment or anything, there was no money left to go towards that. E&O really exists as a consumer protection measure. We realize that people make mistakes, and that's what errors and omissions insurance is for. And we're also supportive of it being used to provide you some legal defense. However, we're revising the rule to ensure that legal defense limits are outside of the claim limits so that we don't have the issue of somebody exhausting all of their funds on their legal defense and then not having any funds to go to rectify the issue for the consumer. So that should be slated for the August meeting, and you're more than welcome to submit comments if you want to do it electronically. You can also come to the meeting. They're public meetings, and they are the first Tuesday of every even-numbered month, and they start at 9 a.m., and they're typically held down at the division offices at 1560 Broadway. One of the other issues that we're working on addressing for the real estate brokers is the issue of legalized marijuana. Since it's become recreational marijuana has become legal, one of the questions is what do I have to disclose? And I've heard a lot of brokers say, well, I don't have to disclose it anymore. I'm kind of conservative as far as I don't know that that's necessarily true, so I'm really having the AG evaluate that. We also have an issue on the appraisal side about what they need to be disclosing in their appraisal reports, because you've got the federal banking issues, and it would be a violation of their license law to somehow gloss over or omit the fact that a property is used for marijuana production, like a grow operation. So we're having the AG work on it from the perspective of the real estate broker and the appraiser perspectives. The mortgage loan originator perspective seems to be a little more cut and dry because they are dealing with the federal lending requirements. But any guidance that the AG's office can provide on that, we'll try to disseminate that to the mortgage loan originators as well. It's still in the early stages. The AGs have told us that this is really a complex issue, and it's not as cut and dry as some people would like to think. I will tell you that once they get their legal analysis done, what it amounts to is we're probably going to have to take it to each of the respective boards and commissions for them to make a policy decision on how they want to deal with marijuana. Once they make the policy decision, we will email it out to the industry so that you're well aware, and I anticipate that we'll probably do a newsletter article because I know that a lot of people don't get all of our email blasts that we send out. So that is coming as well. So to give you an idea of kind of what the common complaints are that we typically see with the real estate brokers, and this is kind of old hat, we don't really see any emerging trends right now, which is a good thing from our perspective, but failing to disclose material facts is an ongoing issue, whether it be radon, asbestos. We see pest infestation issues that have gone on from one sale to the next sale of the property. I remember when I was a broker, my managing broker had words of wisdom of when in doubt, disclose, disclose, disclose. I would impress upon you that motto as well. We also continue to see issues with criminal convictions. One of our leading complaint generators for the real estate brokers and also the mortgage loan originators is criminal convictions. There's a whole laundry list of criminal convictions under 1261-113-1M that could equate to a license law violation. And I know a lot of the time, if you're going through the criminal justice system, the defense attorneys typically will tell a broker that, you don't have to worry about reporting it if it's not a felony. That is not the case. 1261-113-1M has felonies and misdemeanors, so you really need to look at that. And we see anything from a bar fight, which I will tell you will not cost you your license unless you're having a bar fight and it's over a commission dispute with your client, then it might, up to forging real estate documents, burglarizing your own listings. If you're trying to hire an undercover police officer to kill your spouse, typically that's not somebody that we want to license either. But just bear in mind, if you're having interaction with the criminal justice system, make sure that you look at the list of criminal convictions, even if it's a conviction, a plea of guilt, or an Alford plea of no contest. You need to report that to us. And it may or may not mean that you're going to face discipline. In some cases, if it was a bar fight, you may look at a fine and a public censure depending on what the circumstances were. But we do understand that people do interact with the criminal justice system, and it's not always going to cost you your license or result in significant discipline. We continue to see a lot of issues with the uniform duties or the minimum requirements of the license law. I still get a lot of complaints about those brokers that enter into MLS-only agreements. We don't police the MLS, but at the same time, if you are only entering properties into the MLS and that is the only service that you're providing to the consumer, the license law doesn't accommodate that. You either need to fulfill the duties of a single agent or a transaction broker. I will say that a lot of the complaints that we get are on out-of-state brokers. We have one that's currently in the AG's office, and I think that broker's out of Pennsylvania. Previously, we had one that was out of Utah, and I think he ended up relinquishing his license. And we're currently dealing with one that's out of California. If you're seeing these entry-only types of brokerage relationships, please report those to us so that we can deal with them. It really creates kind of an onus on the industry, particularly if you're the buyer's agent, because you're having to toe a fine line of fulfilling your duties to your buyer and also trying to help navigate an uneducated seller through the process. And it puts you in a precarious position, and in some cases may even look like dual agency, which is not allowed under the Practice Act. And sometimes you may be acting as a transaction broker when you have signed up to be a single agent for your buyer. So please notify us of those violations as you see them. We continue to see issues with brokerage relationships. It's really not a good idea to be a transaction broker for your child or your spouse or a long-term business partner. A lot of the time what we see is that it would really have been appropriate for you to be a single agent. So just bear that in mind. I've gone over the contracts issues that we've seen. I can't reiterate enough that if there's not a commission-approved form out there that works for the transaction that you're dealing with, an attorney needs to be hired to deal with it. And if it's a situation where it's a really complex leasing agreement or sales agreement and the contract to buy and sell just isn't fitting, then the buyer or the seller need to look at hiring an attorney to draft that contract for them. Lastly, we went through back in January and revamped our brokerage audit process, really to make sure that all of our financial examiners are on the same page and to make the most efficient use of time. It's not efficient for us to drive all over the state doing brokerage audits when some companies don't hold trust funds, others do. So what we've done is we've established kind of a three-tiered audit process. One is where we do just kind of a survey to see what, if any, type of trust accounts you manage. Another one is to do a desk audit process. And then we do on-site audits if you kind of fall into that high-risk category. And I will tell you that property management falls into the high-risk category just kind of by virtue of what that area requires. So we went through and revamped the process. We are now out doing about 12 to 15 audits per month. I think we did 14 in May. And with the on-site audits, unfortunately what we're seeing is we continue to see brokers that are mismanaging funds. And when we see that you're mismanaging funds, we're trying to narrow it down to kind of the two buckets of, do you not know how to do the required accounting? Was there a mistake made? Is it an accounting software usage problem versus the theft issues? And we do see quite a few theft issues. And when we see the theft issues, those are going to the Real Estate Commission. What starts as an audit kind of blossoms into an investigation that then goes to the Real Estate Commission. I will tell you, though, that when we're seeing theft, we've got a statutory requirement to report any potential criminal violations to the appropriate criminal law enforcement agency. So we do work with law enforcement once we deal kind of with the initial settlement offer that we're going to provide a broker that comes down from the commission. We're then referring it on to the appropriate criminal law enforcement agency. If it's a mathematical error or a software usage issue, we are trying to work with the brokerage to get them on the right track so that they are doing the accounting, the three-way reconciliation as required, that they know how to use their software, and if it's antiquated, that they get up to speed and use a program that better suits their needs. If they're mathematically disinclined, we help them learn math. We'll put them on the road of having kind of periodic audits just to make sure that their processes are improving. Really the goal is to bring them into compliance, whereas if you're inclined to commit theft, we don't want to have you in the industry. You need to go pick a different profession. So I will say that the trust account issues and property management issues continue to be a big issue for us. And because of that, back in December, the Commission discussed kind of the need for a specific property management designation. This is something that we're going to start evaluating, and we'll be evaluating it kind of in anticipation of the Real Estate Commission's sunset review process that will be coming up. They may start it next year. If it's not started in 2015, it will definitely happen in 2016. But we'll be evaluating kind of what the additional criteria ought to be. I know that state of Nevada requires just kind of a property management endorsement above and beyond the standard qualifying education to get a broker's license. That is something that the Commission has kind of discussed, that you'd have to have an endorsement above and beyond that sales license. So that is something that we are contemplating. To give you an idea of kind of what the industry stats look like currently, we have got 38,597 real estate brokers licensed in the state of Colorado. Typically 25% of those are inactive. We have 2,776 appraisers. I will say that we continue to see a decline in their numbers. Practice standards for appraisers are not getting easier. They're actually getting tougher, and they've got new criteria that goes into place in 2015. So I anticipate that you'll see a further decline in their numbers, particularly if income for the appraisers doesn't go up to kind of match the criteria. that's required of them. And then currently we have 7,817 mortgage loan originators licensed in the state. That is the one industry that really seems to be coming back and is thriving. And I think that's just kind of reflective of our market changing. So that's kind of the Real Estate Commission in a nutshell. The big issue that I think will affect the brokers that the division is working on is community association manager licensing. That will start. You'll have to be licensed as a community association manager if you do community association management duties, and those are defined in statute come July 1st of 2015. If you do one or more of those duties and you do them for compensation, you'll have to have a community association manager's license. Real estate brokers are not grandfathered in, and you'll have to get a separate credential type. What we have been doing is we've published just kind of a preliminary draft of rules, and they do mirror the real estate broker program to some extent. And when this bill was first run through the legislature last year, one of the things that was communicated to us was they had taken the Real Estate Broker Practice Act and just kind of mirrored it for community association managers. And while we see a lot of similarities, there are some significant differences for community association managers. For instance, if you've got a community association management company, the CEO is going to have to be licensed. The individual managers will have to be licensed. Anybody that directly supervises them will have to be licensed. And we're going to be trying to parse out, we don't want to have the domino effect extending upwards from the people that are providing the actual services all the way up through all of the management of the company. And we're going to try to work on how to define who needs to be licensed and who doesn't. Some of the other ambiguities in the license law is the duties that require licensure are significantly similar to some of the duties that are exempt from licensure, that are defined as clerical. So we also need to kind of work that out because, as an example, accounting requires licensure, but it's also exempted to some extent. So we need to figure out how the industry practices and what needs to be exempted and what needs to have the license. But we've published those initial rules. They're up on the website if you want to take a look at them. You can still provide feedback. We have no way started the formal rulemaking process, and we actually can't start rulemaking until January 1st of 2015 when the bill itself goes into effect. Kind of what I anticipate, it won't be January 1st because I'm not coming in on New Year's Day. It's a director's model program, so on January 2nd, 2015, we will have an emergency rulemaking hearing to adopt licensing rules so that those are in place and people can start the processes that they need to do to become compliant with the license law by July 1st. There's currently 3 designations recognized under the Licensing Act, the PCAM, the CMCA, and the AMS. We're working with our education task force to go through some of the other industry designations to see if some of those could basically qualify as pre-licensing education under the Practice Act. And if there's gaps, what we'll do is we'll just have kind of basically work with them to identify those gaps and supplement their education, possibly with one of the components of the licensing requirements that we're establishing at the division level. One of the issues when you start designating that you've got to have an industry-specific type of designation is it's kind of against our philosophy that you have to be with a trade organization in order to get a license. So we are working to define our own education so that nobody has to join a trade organization in order to get a professional license. The Education Task Force should have a draft of that education done by the end of July, and we'll get that out to the educators so that they can start providing the education kind of along the lines of the Commission Update course where we do the content outline and then the educators kind of supplement it. So that should be coming out by the end of July. So people should have ample time to get their education done. It's only 24 hours. You'll have to pass an exam. And for the community association managers, they will have to go through fingerprinting, and they're going to have insurance requirements. And we're trying to also define by rule what type of insurance you'll have to have based on what type of management you're providing. And kind of, if you're one of the larger companies, you'd have a different insurance requirement than a small mom and pop where you're only doing one maybe association. So we're working on those. I know that one of the common questions for the brokers and also the appraisers who are now going through fingerprinting is, can we use your broker fingerprints for the community association manager fingerprinting requirements? And we can't, because there's specific statutes that require fingerprinting for those different licenses. So you're going to have to go through fingerprinting again if you're a broker that's looking at getting licensed as a community association manager. One of the other unique things about the community association manager licensing is that the company itself will not be able to get a license until the designated association manager and anybody that has to be licensed has passed the exam. And this is a little different than the employing broker requirements on the brokerage side. So we're going to work as best as we can with the industry to try to make this as painless as a transition to licensure as possible. But one of the plus sides is that I actually have to do a report to the legislature that will be due no later than January 1st of 2016 to kind of let them know what issues there are with the Practice Act. And I've already started compiling that list because there are some issues with just kind of implementing this. And if you're seeing things, I welcome your comments. And I already gave you my email address once before, but I'll give it to you again. It's marcia.waters@state.co.us. And just email me your comments. And I think we're going to take a break really quick so that you can send in your questions, and we'll be right back.
Thank you so much, Director Waters. We are now going to take a 10-minute break. The purpose for doing that is to give you one last opportunity to send us any questions you may have. Director Waters will answer as many of those questions as she can upon our return. So we'll see you in about 10 minutes.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
following is based on a true feeling.
So, what are we thinking? Is this the one?
You're really good at this.
And that's what it feels like when there's a Century 21 agent in the house. Smarter, bolder, faster.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if you only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers? What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights? What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the legal hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have in almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Well, welcome back. We have several questions. The first has to do with loan objection. The question is, there is a movement afoot among some listing brokerages to counter all offers with a loan objection deadline of not more than 7 days from MEC. This makes it very difficult for a buyer to make a fully informed decision as to whether a loan is A, possible to get, and B, possible to close. This seems to be an attempt to subvert what has long been a buyer protection and may unnecessarily put buyers' earnest money at risk. Do I have any additional insight? From the buyer's agent perspective, I would say that you need to make sure that the deadline does meet your client's needs. I understand that kind of with the shortage of the inventory, there have been some additional issues that have cropped up. I haven't heard about this particular issue, but definitely make sure that you're giving your buyer time so that they can assess whether the loan is something that is acceptable to them and even feasible. The next question is listing syndication. In the 2014 ACU, one section addresses issues with Rule E8 advertising violations, especially on social media. Is the Commission going to begin assessing fines and highlighting violations of this manner more aggressively? One of the challenges with third-party publishing websites like Trulia or Zillow is that they don't necessarily provide accurate info to the public with regard to properties actually for sale or supplemental notifications via social media that meet E8 standards. So what we're contemplating is if you've contracted with a third-party vendor to maintain your website, we would just want you to have something in writing that shows that within 3 days of your listing expiring, that you notified them to make the change. I realize that these other websites that kind of just cull data from either, CAR's website or RE Property Colorado, you don't have any control over those. So we're not going to hold you accountable for what they put on Zillow or Trulia. But the third-party websites, we want to see that you made an attempt to actually get the expired listing pulled down so that consumers aren't being given bad information, at least on your websites that are maintained. And if there was ever a complaint that came in that said, you aren't managing your expired listings, what we do is ask to see, do you have proof that you've done that? And we'd verify also probably with your vendor, and it shouldn't be an issue. Now, if you're just kind of out there flying in the face of commission regulation, then yes, you're probably going to get assessed fines, and it may become an issue where there is public censure given, or we basically use you as kind of the poster child for how not to do advertising in like a newsletter article, although we don't use your name. So that is something that we could do. We don't anticipate kind of trolling your websites. We just want to deal with the issues as they come up. The next question is ACU timing. Many brokers are taking the ACU late in the year, which defeats the purpose will the Commission be amending its policy regarding the ACU in relationship to license cycle dates? The Commission really hasn't discussed requiring the Commission Update course getting taken within the first 3 months of the calendar year. One of the difficulties currently with the ACU and with license cycles is, I know from the audits, it's the anniversary dates and just getting the ACU within the anniversary dates. So kind of in the grand scheme of things, one of the things that we're looking at doing, particularly when we go through sunset review, is probably transitioning you all back to a calendar date expiration, so like December 31st. That should help with the CE compliance as far as the Commission Update course is concerned. And if at that time the Commission wants to look at doing a requirement where you've got to complete it within the first 3 months, that's something that we can discuss later on. But I think if we were to try to implement that you have to take it within the first 3 months, it is just going to really create a mess with the anniversary dates and compliance with the CE requirements. What goes along with kind of changing the anniversary dates is we're supposed to be transitioning to a new licensing database. It was supposed to come to fruition in March or April of this year, except for our contract never got off the ground and didn't get signed. We've fixed the contract issues and we're now trying to get signatures. So we all down at the division have our fingers crossed that this new licensing database will go into effect in March or April of next year, which will further ease our ability to kind of manage the December 31st renewals. The next question has to do with your transaction files and documentation. Our office is going paperless. We all have the CREC required and relevant transaction documents scanned and saved on our network and backed up in the cloud. The first question is, in your opinion, what other documents should be scanned and kept separately from the CREC required and relevant transaction documents? And I can tell you from having been an investigator with the Commission, if you've dealt with a particularly challenging client, or there's somebody that's just not happy with how their transaction resulted, I would probably save any notes or communications for those transactions, because you never know what might come back to haunt you. And there's no statute of limitations really for filing a complaint on a real estate broker. Regulation goes back to the 1920s, so that would be kind of the cutoff for when we'd be able to investigate complaints. We do get old complaints in, and these stem from business relationships that have extended over 30 years, and the crux of the complaint may have begun 30 years ago. So I think we all know when we've dealt with somebody who's a potential problem, so I would definitely save any correspondence that you have regarding those transactions. The second question is, if you move everything to the cloud and you are maintaining all of the required documents, will this meet the transaction record requirements of the CREC? And what it amounts to is we don't have an issue with you maintaining them electronically. We just need to make sure that if we're going to audit you, that we have access to those. So you need to make sure that there is some way, there's some method there that we'll be able to gain access, either through complaint or through audit. I would love it if the division could go to a cloud-based electronic model, but I don't think government is going to be there anytime soon. And then the last question is, how will this affect location and what the Commission will be looking for when they audit a property that only has electronic documents? It's not going to change what we're going to look for. It's just going to change kind of the method of delivery. Versus, basically, are you giving us paper versus electronic? We actually encourage that you give us electronic documents when possible. I really don't see this as being a big issue for us when we do the audits, both the desk and also kind of the on-site. So we received a question about builders. The question is in this market, it seems that more builders are unwilling to work with a buyer's agent if they weren't with their client the first visit. The buyer's reps are not explaining the agency relationship and then forcing buyers to forego their right to representation without being educated on the choice. Can this somehow be addressed in the future? Shouldn't they be held to the same minimum standard? And I don't really think this is an issue that has changed over time. I remember it being an issue when I practiced. Unfortunately, we don't have any authority over builders, so we can't make them do anything to kind of promote the role of a buyer's agent. The best advice that I can give you is that you just need to really kind of educate your buyers that if they're going to go out and shop new construction, that they really need to take you out there with them if that's going to be the criteria that the builder's going to establish from the get-go. And that's pretty much that I have on that, unless builders are someday regulated, which I really haven't heard anything on the legislative side that would come to fruition. We received a question about rule changes, and the question is, are rule changes discussed going to be vetted with the brokerage community prior to implementation? And that is definitely something that we will do. Sometimes when we deal with rules, it's easier to parse out who we need to kind of include as far as gathering suggestions, comments, or concerns. For example, if we're going to change brokerage supervision requirements, it's pretty easy to kind of vet it to the employing brokers that are licensed with us because it's going to directly impact them. They're a smaller segment of the population, and it's kind of easier to manage that process. Just like when we're looking at dealing with commercial real estate brokerage, we're going to reach out to the commercial brokers because they're the experts in the field, and they can really tell us kind of from their standpoint what the industry practices are. When we deal with something that has a broader impact across the entire brokerage industry, that becomes a little more challenging to try to gather input prior to even starting the formal process. But I do anticipate, like with the advertising rule, and then some of the forms rules, we still have the capacity before we even go down the formal rulemaking path to kind of send out an email blast to all of the licensees to let them know that these are the proposed changes, this is what we're looking at doing and why, and get your feedback. And I think it also helps communicate to you all why we're looking at making rule changes, which I know on the form side, when the forms have changed every year, the industry hasn't really understood what the basis of the changes were. So if we can help with that on the regulation side, we're more than happy to do that. So you will see those rules getting vetted to you all before we start the formal process. We've got a few other questions. One has to do with the MLS, and it asks that I define what the issue is regarding the MLS entry-only listings. So basically, whether you're a single agent or a transaction broker, there is a list of duties that you're expected to comply with under the license law. You're expected to exercise reasonable skill and care, present all offers, notify the person that you represent in the transaction of any risks or advantages of the transaction, make disclosures, mandatory disclosures, particularly about material facts. You're supposed to do all of those things, and if you're just doing an MLS entry listing agreement, all you're agreeing to do is just put the property into a database, and you're not providing any of the other duties. So you're not exercising reasonable skill and care. You're really not guiding them through the transaction. They're kind of on their own at that point because all you've done is put it into the database. And those are the concerns that we have, is that the license law as written really doesn't provide you with the opportunity to pick and choose which of those duties you do or don't want to perform. It allows you to incur additional duties, and those need to be in writing, but those are the basic duties, those enumerated either under single agent or transaction brokerage. And so if you've got any further confusion, I would really suggest reading those statutes. They're in Chapter 1 of the manual, and the Brokerage Relationship Act, I believe, starts off with 1261, 803. Brokerage relationships are 804, 805, and 807, I believe. So the next question is regarding theft. Kind of an off-subject kind of question, but what is the Real Estate Commission stance on brokers just allowing their buyers to see the property alone? Basically, you open the door for them and they go in and take a look at the property. Well, so I guess that's better than just giving them the lockbox. We would have competency issues with you if you did that. Your errors and omissions insurance, fortunately, will cover any property damage that may occur when you show the property. So if somebody bumps into a piece of art, breaks a plate or whatever, your E&O will cover that. If you're allowing them to just go in, God only knows what they're doing in that property. And we've gotten calls, and this was before marijuana was legal, we'd get calls where somebody had stolen somebody's stash of marijuana, and what should they do? I don't know that I would have called the police when that happened to report that, but you run the risk of potentially being an accessory to theft, and we don't want to see you in that position. We definitely don't want you to be in a position where you're just kind of placing a seller at risk of being a victim of a crime either. So from the commission standpoint, I would not encourage that you just open the door and allow them free roam of the property, at least go into the property and try. I know that they want to have kind of their own privacy as they walk through it and be able to discuss things outside of broker earshot, but do what you can to make sure that you're kind of maintaining the security of the property. And I guess if you want to see E&O claims, that's another reason to just let them wander in and break or steal stuff so that you can enhance your E&O claims. I would not recommend that at all. The next question has to do with forms. There's some clarification that's being sought. The brokerage's attorney needs to prepare transaction-specific forms, disclosures, and addenda. Does this apply to individual clauses inserted into a CREC form? And it would include clauses. That is one of the modifications that we're looking at making for F3, is that the clauses that the brokers are using, and this is separate from, the seller will provide the buyer a $2,000 carpet allowance. When you're actually dealing with clauses that pertain to ways that somebody may get out of the transaction, something that affects their rights, that needs to be drafted by the brokerage firm's attorney, unless you've got an attorney specific to the buyer or seller that's interested in drafting clauses. I know that when I practiced, we had some clauses that were drafted by the brokerage's attorney specific to insurance requirements that all of our brokers were using. We're not looking at changing that, but those do need to be drafted by the brokerage's attorney. And then lastly, there's a question about mold disclosures. The person that submitted this indicated that they're regularly seeing a request for a mold disclosure, but this is not a commission-approved form, nor do they see any attorney heading on the form. Most are the same form regardless of the brokerage requesting them. And do I have any insight on that? So one of the things that we're looking at changing for F7 and also F3 is to make it clear, particularly with F7, that when you're using a form that has been drafted by the brokerage's attorney, it needs to have the brokerage's attorney's name on it. This kind of serves our purpose of when we get a complaint and we start seeing forms that are not commission-approved forms that are being used. We know that we can contact that attorney to verify that did they in fact draft that form. This will reduce the issue of also plagiarism within the real estate industry, where I take one attorney's language and I somehow kind of modify it to meet my needs, which I wouldn't be able to do anyhow under my license as a real estate broker. And we also want to discourage the industry from saying that they are using an attorney drafted form when they're not. It's actually a form that they've drafted. So that is something that I anticipate as we move forward. Everybody seems to be kind of on board with disclosing the attorney's name on the form. So that is a change that you'll see kind of coming down the pike unless we hear a lot of industry outcry about that. But if you're interested in having a mold disclosure form, you can always submit a suggestion to the forms committee. We are going to be kind of working with the Real Estate Commission on what direction they want to go with the forms committee. At their August meeting, we'd gotten feedback from the working group about what is working with the current forms and what is not. And at the August meeting, we'll also be kind of deciding on what direction the commission wants the forms committee to take in the upcoming year, knowing that we'll have forms changes that will need to be made that will go into effect January 1st of 2016. So you can submit the suggestion to us. If they don't take the ball and run with it, contact your brokerage's attorney and see if they'll draft a mold disclosure form for you to use. And with that, that is all the questions that we have. I really appreciate this opportunity to do a webcast with Carr, and thanks for participating today. We'll go back to Julie.
Thank you again, Director Waters, for that update. We appreciate you taking the time out of your busy day and spending the morning with all of us. Thanks again to First American Title and their continued support of our webcast program. And of course, we want to thank each of you for joining us today. Now, coming up on June 25th is another opportunity for you to complete the required 2014 Annual Commission Update course. Be sure to register early as space is limited for that CE course. Visit coloradorealtors.com to register and also check the schedule for the other webcasts we have coming up this summer. That's it from here. Take care and enjoy the rest of your day.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if You only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers. What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights? What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the legal hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.